Welcome and thank you for standing by. All participants will be in a listen-only mode until the question and answer today's call. At that time, if you would like to ask a question, you may do so by pressing star, then 1 to record your first and last name. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I would now like to introduce your host for today's call, Mr. Bill Meyer. You may begin.
Thank you. Welcome to Session 3 of OCSE's Intergovernmental Forms Training. As announced, I am Bill Meyer. I'm an OCSE Program Specialist, and I will be the moderator for today's session. Debbie Ward from OCSE's Division of Policy and Training and Jeanette Savoy from the Center for the Support of Families will provide today's training. As in previous sessions, you will have the opportunities to ask questions over the telephone, and you can submit written questions in the Q&A section of the web presentation. We have a panel of OCSE staff on hand to assist in responding to your questions. And just another quick note, OCSE sends invitations for this training to participants of the previous sessions. Some participants have questioned how to register for this session, and it appears their invitations went to their junk mail folders. So for the next training, you might check your junk mail folder if you do not receive the invitation to register. Before we begin, let's briefly review the forms we've covered so far in this training course. In the first session, we discussed the general changes that impacted all of the forms, and we discussed 2 new forms, the Child Support Agency Confidential Information Form and the Personal Information Form for UIFSA Section 311. We also reviewed the Transmittal Number 1 Initial Request and the Transmittal Number 1 Initial Request Acknowledgement. In the second session, we talked about the Transmittal Number 2 Subsequent Actions, the Transmittal Number 3 Request for Assistance Discovery, the Letter of Transmittal Requesting Registration, and the Uniform Support Petition. In today's session, we will cover the General Testimony and another new form, the Request for Change of Support Payment Location pursuant to UIFSA Section 319. In our final session, Session 4, scheduled for June 27th, we will cover the rest of the individual forms. That would include the Declaration in Support of Establishing Parentage, the Notice of Determination of Controlling Order, and the Child Support Locate Request. Now I would like to turn it over to Debbie Ward to begin today's training.
Thank you, Bill, and welcome to the third session of the Intergovernmental Forms Training. Let's get started with slide 1 of the General Testimony. The General Testimony provides a framework for providing the detailed information and evidence necessary to support the action requested in the Uniform Support Petition and should be included with all requests. To allow the forms to be used by non-state agencies such as tribes, foreign countries, and even private attorneys where appropriate. During the Intergovernmental Forms Review process, the Office of Child Support Enforcement, or OCSE, which we'll be using going forward, and the National Intergovernmental Work Group, or Work Group, which we will be using going forward, had lengthy discussions about what to include in and what to remove from the General Testimony. The goal was to provide the information that would be needed in the majority of cases and remove information that was rarely, if ever, needed. The unusual case where information is required that is not on the form, you can provide extra information in Section 9 or as an additional document to the form. While the General Testimony is used by the petitioner to provide detailed information to support his or her UIFSA petition, there will also be cases where a respondent living outside the forum state is permitted by the tribunal to provide testimony using this form. Given the complexity and volume of information requested in the General Testimony, and the fact that the client is often filling out the form on their own, OCSE added a note at the top of both the form and the instructions directing that the state must provide the instructions to the petitioner. The revised form, along with the instructions, allow the user to provide all the complex information needed for legal action. In the form heading, the statement, "This form contains sensitive information. Do not file this form in a public access file," highlights the sensitive information contained in the form. But ultimately, state law and tribunal rules control how UIFSA forms will be filed with and held by the tribunal. As noted in the heading, the information in the form will be filled in the responding tribunal with a pleading or petition and provided to the respondent unless a nondisclosure finding or affidavit is attached. If the nondisclosure claim is contested, the tribunal must decide in accordance with UIFSA Section 312 what, if any, information may be released to the respondent. As we have discussed in previous training sessions, you must include the new personal information form for UIFSA 311 with any general testimony submission when you're submitting that to another jurisdiction. The personal information form for UIFSA Section 311 must always accompany a general testimony because it includes the information required under UIFSA Section 311 in any action to establish a support order, determine parentage, or to register or modify a child support order. As you may recall, you must also attach the other PII form, which is the Child Support Agency Confidential Information Form, if you're sending the general testimony as part of an initial request using the Transmittal 1 for a responding agency to open an intergovernmental case. The confidential information form contains all the PII that the responding agency needs to build the responding case on their system. These two forms serve different purposes but share some of the same data. The general testimony cannot be sent via Child Support Enforcement Network, which is SESNET, but is one of the documents that can be provided through the Electronic Data Exchange, or EDE. In the area where the name of the parties are listed, you will see we have used petitioner and respondent. The designation of petitioner or respondent is a state system or state pleading issue. The work group added checkboxes to the heading to indicate if the petitioner and respondent are the obligee or obligor to align the general testimony terminology with that of the Uniform Support Petition. Okay, so now let's go on to slide 2 of the general testimony. As we mentioned, much of the PII has been removed from the forms. The personal information that remains on the revised general testimony might be needed by the tribunal during the course of the action. We realize that in many cases, state systems will fill in much of the form. It is very important then to ensure that the petitioner completes the necessary sections that you proofread the form before you provide it to the other state. These simple steps can avoid confusion and ensure the responding tribunal has the necessary information to proceed. With UIFSA 2008, an affidavit or a document incorporated by reference in a federally required form now requires the form to be given under penalty of perjury instead of being duly sworn before a notary public. We will cover this in more detail at the end of the general testimony. So Section 1 provides personal information about the obligee. Remember that the petitioner may be either the obligee or obligor. Parts A through D ask questions about the obligee parent. Part A addresses the obligee parent information, such as name, gender, and occupation. The information about tax filing status was added to provide the tribunal with information needed to determine the party's income. Part B addresses the obligee's physical description, such as race, height, and weight. This is most often used by the process server to ensure the correct person is being served. Part C provides the information regarding whether or not the obligee parent is responsible for dependents other than the children of this action. The children of this action are listed in Section 4. If that information is not known, then you would check unknown. Part D provides information regarding whether the obligee parent has an existing support order for the other dependent children listed in Part C above. Again, this is not the children of this action, and information about the orders for those children. Again, if that information is not known, then you would check unknown. This section also requests that you provide a copy of the order. We understand that the petitioner may be the obligor and may have a difficult time obtaining a copy of an order to which they are not a party. The 4D agency may need to assist them in obtaining the order. In both Parts C and D, there is room on the form to provide information for 3 children. We are only showing the first child on this slide. The same information is required for each child listed. If there are more than 3 children involved, provide information about the other dependents in Section 9, Other Pertinent Information. Okay, so now let's move on to Slide 3 of the general testimony. Continuing on in Section 1, Part E provides information about the obligee or caretaker that is not a parent. If the obligee caretaker is filling out the form, he or she may provide any other relevant information in Section 9, such as out-of-pocket expenses incurred by the caretaker or obligee. Section 2 contains personal information about the obligor. The obligor may be an individual who owes or is alleged to owe the child or children a duty of support, or a person who is alleged but not has been adjudicated to be a parent of the child or children. Section 2, Parts A through D, requests the same information as Section 1 did for the obligee. Because a caretaker would never be an obligor, there is no space for caretaker information in Section 2. Okay, so now let's move on to Slide 4 of the general testimony. Part D at the top of the slide requests the same information as Section 1 did for the obligee. Section 3, legal relationship of parent or child, listed in Section 4, identifies the relationship between the parents of the dependent children for whom parentage or child support is at issue in this action. If more information is needed than will fit in the space provided, check C Section 9 and enter the information in Section 9. The information in Section 3 is critical for the tribunal to take the appropriate action. It provides information the tribunal needs to ensure parentage has been or will be established. More than one checkbox may apply, so be sure to provide all applicable information. This section is much the same as it was on the old version of the form. We removed the option for separated from the revised form as it has no legal implications. Rather, the option for legally separated is included on the form. So now let's move on to Slide 5 of the general testimony. The Section 4 is for dependent children in this action. That's what we talked about before. This is the one where the children for this action would be listed. And you list all the children of this action for whom the parentage and or support is to be established or for whom support is to be modified. These should be the same children listed in Section 1 of the Uniform Support Petition. List only those children of the obligor named in this action. Provide complete information for each child. The date of birth and Social Security number for each child is on the Personal Information Form for UIFSA Section 311, so they're not included on this form. If parentage has not been established, be sure to attach a separate declaration in support of establishing parentage for each child whose parentage is at issue. Under Item A3, provide the amount of child care paid for each child, as many state guidelines factor child care expenses into the support obligation. So some children of the order may require child care, while others may be old enough that the child care does not apply. The form also requests information regarding whether a support order has been established, whether the child resides with the petitioner, any financial benefits the child receives, such as Social Security and tribal affiliation. If the child does not receive benefits of this type, it's very important to indicate, if they do receive benefits of this type, it's very important to indicate whose claim the child's benefits is based on and his or her relationship to the child, so that the tribunal knows whether to consider this information. For example, if the child receives Social Security disability under the obligor's claim, many states consider these benefits in setting the support amount or offset the support due by the amount the child receives. As we have done earlier in this training and on other forums, we only show the first child on this slide. Same information required for each child listed in the action. There's 3 that are listed on the complete form. If there are more than 3 children involved, information about the other dependents can be provided in Section 9, Other Pertinent Information, or in an additional document. Now I'm going to turn this over to Jeanette Savoy, who's going to talk about health care coverage.
Hello, everyone, and welcome. I'd like to now draw your attention to the lower section of the slide number 6 for the general testimony, again highlighted in blue, and we're going to begin to discuss the health care coverage section. Section 5, health care coverage, is used to determine if health care coverage is currently being provided for the dependent. The information also provides a basis for adding health care coverage to new or existing orders. This section contains substantial changes from the old version of the form, reflecting new information required by the Affordable Care Act and 4D medical support requirements. You'll also find that a number of things have been removed from this, which really don't apply when determining health care coverage for the children. Health care coverage may include, but is not limited to, Medicaid, TRICARE, Indian Health Service, employer coverage, an individual policy, a state or federal health insurance exchange or marketplace policy, and cash medical that's been ordered. Part A on this highlighted in blue is health care coverage for the children, and this requires information for each child of this action. Again, that's the children named in Section 4. Items 1A and B request the name of the child and the type of coverage, if any, and provide directions as to what additional items to complete in this part of the form, which we will look at on the next slide. So moving on now to general testimony, slide 7, you would provide detailed health care policy information for the child in item 1C, along with the premium, and note whether or not this is a child-only policy under item 1D. Again, we're looking specifically at each child, and we're only showing one on the form. Items 1E and 1F relate to who claims the child for federal tax purposes, which may affect who is ordered to provide health care coverage. For example, if the father is the obligor and is the person who claims the child for tax purposes, the tribunal might order him to provide health care coverage. Under Part B, health care coverage for the petitioner, items 1 through 3, ask some similar questions about health care coverage in which the petitioner is enrolled or could enroll in, whether coverage is available for the child, and the cost of any employer-provided policy. Note that the form itself does provide some instructions as to which items to complete based on the petitioner's responses. Under item 2, calculating the monthly premium and premium amount for the child can be somewhat confusing. Many states' guidelines take into account only the portion of the premium that is paid for the child or children of this action. The form's instructions include detailed information on how to calculate this if needed, and that's one of the reasons we encourage you to provide the instructions to whoever is filling out the form. Now we're going to continue with health care coverage for the petitioner, and we're on slide 8. Looking at the general testimony, slide 8, you're going to complete items 4, 5, and 6 only if the petitioner does not have health care coverage. The tribunal would use this information to determine the best option for ordering health care coverage for the child or children. For example, in reviewing the responses to these questions for both the petitioner and respondent, we're going to see similar questions for the respondent, both parties might have employer-sponsored coverage available, but the respondent's coverage might not cover the children as it's not available in their geographic area. The tribunal, in that example, might order the petitioner to provide the health care coverage. Part C, in the middle of the slide, begins with the questions for health care coverage for the respondent. And that's what you see on the lower portion of the slide. They're essentially the same questions, and in many cases, the petitioner may not have that information available. If so, it's just to be left blank or marked unknown if there's an unknown box. Now, on the general testimony, slide 9, the upper portion shows the continuation of Part C, health care coverage for the respondent, which again asks the same questions about health care coverage available to the respondent that we reviewed in the petitioner's health care coverage section. Again, in many cases, a petitioner may not have that information available. Continuing now with the highlighted section 5, which is health care coverage Part D, E, and F. These include questions related to children's special needs or medical expenses, reimbursement for medical expenses paid, and compensation for ongoing medical expenses. Remember, though, that when establishing a support order, the law of the responding jurisdiction determines whether and how past and ongoing medical expenses are included in the support order. For example, some states consider only expenses above a threshold amount or those costs that are for specific ongoing costs. The expenses in Part D through F may not be reimbursable or allowed in all jurisdictions. Part D asks whether a dependent in this action has special needs or extraordinary medical expenses not covered by insurance. This includes special medical needs and medical equipment. The form provides space for details about the child or children involved. You would enter the type of need or expense and related costs in Section 9. Also, provide documentation of the special need or expense, such as a doctor's statement or a receipt for the payment. The form instructions direct the petitioner to detail any agreement between the petitioner and respondent to cover these costs, and that includes agreements that are verbal, written, or obviously part of any court or administrative order. As the petitioner might be the parent who does not have physical custody of the child or children, unknown might be checked. Since this information is provided by one of the parties, including this type of information on the general testimony is not a violation of the Health Insurance Portability and Accountability Act, which we know as HIPAA. Part E asks whether the petitioner is requesting reimbursement from the respondent for any medical expenses paid. If yes, enter the balance and the date accrued, and provide the date, type of expense, such as doctor's visits or prescriptions, and the cost, again in Section 9. Finally, in this section, Part F asks whether the petitioner is requesting the responding tribunal to order the respondent to share the cost of any ongoing medical expenses being paid by the petitioner and not covered by insurance, such as dental service copayments and allergy shots. If yes, enter the type and medical expense and the amount and frequency of the cost. And again, you can provide additional information in Section 9. It's important to note that these forms are used by both, this form is used by both 4D agency and as well as private attorneys. Now I'm going to turn it back over to Debbie.
Thanks, Jeanette. We're on slide 10 of the general testimony to discuss Section 6, additional information for child support calculation. This section contains information relevant for child support calculations in many states when establishing a support order or modifying an existing one. Because state child support guidelines vary, the information the responding tribunal will use for the calculation will vary. This section consolidates information that was in various other sections of the prior version of the general testimony. This section breaks out information into two parts. Part A is establishment, Part B is modification. So for Part A, that contains questions related to the establishment of an order when there's no existing support order. For some states, child support guideline calculations consider the amount of time the child or children spend with the obligor. Generally, states use the number of overnights the child or children spend with the obligated parent to calculate any applicable adjustments or deviations. It may be difficult for the petitioner to provide the exact number of overnights. If so, provide an estimate. If there is a court order or binding separation agreement indicating custody or parenting time, those terms, you should attach that to the form. Complete item 4 if child support is being sought for a period prior to the date on the uniform support petition. That date was when the petition was signed. State law controls whether the tribunal has the authority to grant support for a prior period and the time period allowed. When seeking retroactive support, item 4C requires disclosure of all support received directly from the obligor during that time period. Finally, the period of time the family received public assistance benefits may be relevant in setting an award for a prior period. Provide this information in item 4D. Where the petitioner's public assistance benefits had multiple on-off periods, provide that information in Section 9, other pertinent information. During the revision process, we received suggestions to add the amount of public assistance benefits expended to this section. However, since the tribunal is required to follow the guideline calculations based on the party's income, the amount of past public assistance expended is not relevant to the amount of prior support ordered. Now let's move on to slide 11 of the general testimony. And we're going to be continuing with Section 6. Additional information for child support calculations, Part B, has questions related to the modification of an existing support order. The section begins with the legal basis for modifying the support order. Examples include a substantial change in income of either parent or the needs of the child, or at least 36 months have passed since the order was established or since the most recent review of the order. Note that some states have a shorter time requirement than the federal 36 months that's in regulation. Item 2 through 4 are similar to the questions we saw in the establishment section and provide information about any custody or parenting order and the number of overnights the child or children have spent with the obligee and obligor over the past 12 months. So now let's move on to slide 12 of the general testimony. Section 7, support order and payment, supports any claim of arrears or past due support included in the petition. It focuses on support payments, including whether the support order requires the obligor to pay support to anyone other than the State Disbursement Unit, or SDU. For example, the support order might direct the obligor to pay the child care expense directly to the provider. This section also addresses direct payments to the obligee. either pursuant to an order or written agreement or to the voluntary support payments made to the obligee before the support order was entered. You must include an affidavit supporting such payments. After considerable discussion, OCSE and the work group agreed that any such affidavit is best done on a state-specific form. Accordingly, we have removed the payment record that was in the old general testimony form. If a support order does not exist, attach a copy of the order, which is usually a certified copy, and the payment record. Also attach an affidavit of any direct payment or voluntary payment which were made before the issuance of an order. Now let's move on to slide 13 of the general testimony. Section 8, financial information, is used to obtain the petitioner's financial information needed for the responding jurisdiction to apply its child support guidelines. A few states continue to use only the obligor's income, but the overwhelming majority of states consider both parents' income when setting a new or modified child support order. In addition, because states vary in how they define gross and net income, we removed total gross income and total net income to avoid that confusion. However, there's still a line requesting total gross income for the prior period. We removed income information for the petitioner's current spouse or partner, since that person does not have a financial responsibility to provide for the children of this action, so their financial information is not relevant. Because child support guidelines focus on income, the section no longer includes information about monthly expenses or assets. If such information is relevant, the petitioner can provide it in Section 9. It is important to disclose all pertinent information. Failure to disclose information may seriously affect the legal proceedings in the responding jurisdiction and may unnecessarily delay the resolution of the support issue. So now let's move on to slide 14 of the general testimony. Continuing with Section 8, financial information, this section provides information on other deductions that may be considered by the responding tribunal. Mandatory retirement means the amounts that are required by law to be withheld and paid directly from a party's income and deposited in a retirement account or fund. Non-mandatory retirement means amounts that are voluntarily withheld or paid directly from a party's income and deposited in a retirement account or fund, such as a 401k. During the form revisions process, we received a suggestion to add a checkbox to indicate the person to whom the information belongs. We disagreed with this because the petitioner, by definition, is the person or entity requesting the tribunal to take certain actions. The revision to the header information clearly identifies where the petitioner is the obligee or the obligor. Section 9, other pertinent information, allows the petitioner to provide other relevant information he or she believes is useful to the responding jurisdiction. As discussed, it's also the place to put carryover information from other sections where there was insufficient space to provide the detailed response. If the additional information is related to a previous section, identify the section, part, and item number as appropriate. Check continued on additional sheets incorporated by reference if you have more information that will fit into the space provided. Now let's move on to slide 15 of the general testimony. Section 10, attached and incorporated by reference, provides a checklist of documents you may provide to support the general testimony. If a support order was not issued by the responding jurisdiction, you will generally need to attach one certified copy and one additional copy. If the order was issued by the responding jurisdiction, you may not need to include a copy of the order, but it can be helpful to the responding jurisdiction. Check additional attached documents incorporated by reference when including other documents other than those listed. Okay, so now let's move on to slide 16 of the general testimony, which is the last page. Section 11, Declaration, it has a new title, which refers to the fact that UIFSA 2008 no longer requires verification because UIFSA Section 316 requires only that an affidavit or a document incorporated by reference in a federally required form be given under penalty of perjury. The form no longer references a notary public. The person or people providing the testimony, the individual petitioner, the agency representative, or both, must sign under penalty of perjury and date the general testimony at the bottom of the page. By this signature, the person or people are confirming that the information and facts provided in the testimony and all attached documents are true to the best of his or her knowledge and belief. Now I'm going to turn it over to Bill for questions.
Thank you, Debbie, and thank you, Jeanette. That concludes our review of the revised general testimony. We'd like to open up the telephone lines and see if you all have any questions.
Thank you. At this time, we would like to begin the question and answer session. To ask a question, press star, then 1 to record your first and last name. Again, press star, then 1 to record your first and last name. One moment to see if we gather questions.
Thank you. And you can also send in questions on the Q&A on the web presentation if you like. Give it just a minute or two. I don't have any questions coming in on the web.
First question comes from Mary Ellen. Your line is open.
Thank you. I have a concern from the general testimony, slide 16, where there's a declaration made and the tribunal representative is made to sign under penalty of perjury that all the information and facts are true. When we are receiving that information from the party, we have no way to verify that or to know that personally or professionally, but yet we're made to swear that it's true under perjury, under penalty of perjury. Is that not a problem?
I can answer that, Bill, if you'd like.
Thank you. And I think for the most part, the person filling out the form, the petitioner, would be signing there, right? But go ahead, Jeanette.
The most logical time when the 4D representative would be signing it and not a petitioner would be if it's a TANF case. And you see, and that's not different from the old form. That has always been the case, that the 4D representative in a TANF case could sign this. And basically what you're saying is it's true to the best of your knowledge and belief. So it's true, it's the information you got from the party,
okay.
And as far as you know, it's good. But if it's not a TANF case, then I believe the petitioner certainly needs to sign it.
And that would be only the petitioner? It's not necessary for the representative to sign it then?
Correct. Both could sign it, but only the petitioner is required. Would you agree with that, Bill? And
that was my thinking as well.
Thank you.
I do recall we had some discussions about that, so I'd have to maybe we need to double check on that and get a response out to you. But and I'm pretty sure that's the way the previous form was set up, that the person completing the form, the petitioner, would complete the document and then sign it. And if for some reason that signature was unattainable, or as Jeanette described, there was a TANF situation, then the form would need to be perhaps completed in part by the 4D representative and then signed by the 4D representative. Does anyone else have any comments on that? Okay. And I think, do we have any other questions on the phone?
Yes, the next question comes from a caller who did not record their name. Your line is open. Your line is open if you did not record your name. The next question comes from Maureen Morrison. Your line is open.
I gotta go to bed.
Maureen Morrison, your line is open. At this time, we have no questions.
Okay, I do have a question that is coming in on the web. Question is, please confirm that the PII doc must always be sent with the general testimony along with the, I guess, Child Support Agency Confidential Information Form. That's quite an acronym there. If we are sending a transmittal 1 initial request, is there any other time both are required? Well, I think you're certainly correct that both forms would be sent with the transmittal 1 and the general testimony. And I think there might be some other situations where both would be required. Normally, when you're sending an initial request for some actions, and so the general testimony may not be needed in everything, but you might still be an initial request. I'm thinking perhaps, well, and Jeanette, perhaps you can jump in. If we're sending a request for registration and enforcement of another state's order, or I guess registration and modification of another state's order?
Right. I think the thing to think about is, are you asking a tribunal to take an action on the order? So if you're asking for modification or establishment, and it's, as Bill said, you're sending this initially as a case, you're going to include the transmittal number 1, the general testimony, the uniform support petition, and both of the PII forms. If you're sending a transmittal 1 with a request to register and enforce, then you need the Child Support Agency Confidential Information Form, but not the 311 PII. I want you to also know that we're working on a matrix of recommended documents with the federal office. So hopefully we'll have that for you in the next month or so, just to help guide you with what documents go with what type of case.
Thanks, Jeanette. Do we have any other questions on the telephone?
At this time, I show no questions.
Okay, I think I have a couple of more coming in on the Q&A. Slide 11, when filing the paperwork for adding, for adding a child to an existing order, how is it filled out? The information only lists earnings and needs of child. What do we use to add a child? I'm not sure I understand the question. Certainly there's places for multiple children, and you have to provide information on each child.
Yeah, I would fill this in as if you're asking for a modification, because I think that's exactly what they're asking, is adding another child. You need to still list all of the children of the action, because some of that might have changed. You know, that an original child on the order might have needed daycare and doesn't anymore, for example. So I would say I hope I'm answering what you're asking, that you would need to fill the form out for all children and certainly indicate on there that what you're asking is to add this additional child.
I agree, Jeanette. And so adding a child to an existing support order that perhaps already has another child, I would complete the entire document, but you have to make it clear what you're requesting. In that instance, too, you might want to check with the jurisdiction that you're sending it to with regard to your options, whether adding a child is sort of something that can be accomplished there. I think I have another question. In the event that the petitioner is the obligor, and this is a mod request from the obligee, there is no position for income information in Section 8. Do we just attach the document? If the mod request is from the obligee, I'm thinking that the petitioner is the obligee. But anytime, generally, if you have additional information to supply on the parties, you can attach additional documentation and note it in Section 9, as we've said before. Do you have any comments on that one, Jeanette?
No, well, the only thing I would say is that sometimes it is the obligee, let's say, who's asking for a mod, and the obligor is in another state, and they allow them to use this form. So they're not really the petitioner, but I would say whoever is signing the form puts their information. That may be sort of what they're asking here.
Thanks. Are there any other questions on the telephone?
Please. Next question comes from Eleanor Tate. Your line is open.
Hello. I missed the very first training,
and I'm a little puzzled about transmittal number 1. May I ask a question about that?
Sure.
Okay. Number 3 and number 4, it's changed some. When I'm in South Carolina, and if I have a South Carolina order, the petitioner is still in South Carolina, but the respondent may have moved to North Carolina. So I need North Carolina to register and enforce and redirect payments to South Carolina. 3 and 4 don't really say that. Should I just check number 5, other, and make a note, register and enforce South Carolina order and send payment to South Carolina, or should I be using number 3 or number 4? It's just a little confusing to me.
Well, I don't have number 3 and number 4 memorized, but I think we broke it down with regard to requesting enforcement of the responding state's order or requesting enforcement of another state's order. And so if South Carolina is asking North Carolina to enforce a South Carolina order, I believe we had a spot for that. So I don't think the other information, I mean, what you're describing is a fairly standard request. Is that correct?
Right, because number 3 says take the following actions on the responding tribunal's order and forward payment to the initiating jurisdiction's SDU. And then number 4 says take the following action on a support order of another jurisdiction and forward payment to the initiating jurisdiction's SDU.
I think that's the one you want.
So I need to use number 4.
Right.
And then I need to just check A, register and enforce.
Yes.
Okay.
And at the end of this session, we're going to give you an email address.
Okay.
So certainly if you have further questions about it or about any of the other forms, send those in and we'll get a response back to you.
Thank you so much.
I just wanted to add one thing. If you're asking a question, please use the Q&A section of on here, not the chat, because the chat will not be answered. The Q&As will be answered. Thanks.
Okay, good questions, everyone. Do we have any other questions on the phone?
This time, I show no questions.
Okay, and I think we've been through those that have been submitted on the Q&A. Now we're going to get started on our second form for today. That's with a very long name, the Child Support Agency request for change of support payment location pursuant to UIFSA Section 319. And I'd like to turn it over to Debbie.
Thank you, Bill. Before we look at the form, we wanted to go over the basic UIFSA Section 319 because it's new to many states that went from UIFSA 1996 to UIFSA 2008. So UIFSA Section 319B allows a state agency providing services to an obligee to request a redirection of support payment to its SDU. It is available only when neither of the parties nor the child reside in the state that issued the support order, and only if the obligee is receiving 4D services in a new state. After redirection, UIFSA Section 319C requires the state now receiving the payments to provide the order issuing state, upon request, a certified statement of the amounts and dates of all the payments received. Even when redirection is available, there is no UIFSA or federal requirement that a 4D agency providing services to an obligee make a redirection request. Other options, such as payment forwarding and initiating a two-state case, may be preferable depending on the facts and involvement of the order issuing state. However, if a state agency does make a UIFSA Section 319 request, it must be honored by the order issuing state. So how does redirection work? As you know, payments generally flow through the order state's SDU to the obligee, even after everyone has left the state. When there is a request under UIFSA Section 319, to the state that issued the order by the state providing services to the obligee, the first step is for the order state to direct a new payment flow to the SDU and the state providing services to the obligee. Depending on state law, the 4D agency may be able to accomplish this by either administrative or judicial order. The second step is to provide notice of the new payment location to the employer. UIFSA Section 319 gives 4D agencies flexibility in notifying the employer of the new payment location by either sending an income withholding order or an administrative notice of change of payee. It is also a best practice to send a copy of to the obligor so that if he or she changes the employers or sends in direct payments, they will go to the correct SDU. Just a few additional notes about redirection. UIFSA is state law and provides clear legal authority for the agency or tribunal to act when a proper UIFSA Section 319 request is received. The order remains that of the order issuing state. All issuing state terms remain in place, including interest charged. UIFSA Section 319 does not grant any modification authority to the requesting jurisdiction. Its authority extends only to the collection and distribution of payments received. UIFSA Section 319B1 requires the order issuing 4D agency or tribunal to direct all payments, whether some employers or non-employer sources, to the requesting state's SDU. Now I'm going to turn it over to Bill to provide you with a scenario.
Thank you, Debbie. Let's look at a hypothetical case. As illustrated by the drawings, a support order was entered in Texas designating the Texas SDU as the payment location. The obligor now lives in Florida, and the obligee and child now live in California. The first set of diagrams shows the payment flow before redirection. The obligor in Florida is sending payments to the Texas SDU. The Texas 4D agency does not have an open case, and the obligee has not yet applied for services in California, so the Texas SDU is sending the payments directly to the family in California. The second set of diagrams shows the payment flow after the UIFSA Section 319 change in payment location or redirection. Once the obligee applies for services, the California 4D agency must look at all the facts of the case, including whether the 4D agencies in Texas or Florida have open 4D cases. OCSE strongly recommends that the 4D agency contact the order issuing state and check federal resources prior to sending a redirection request. Federal resources include QUIC, Query Interstate Case for Kids, and the response data from the Federal Case Registry, or FCR. The requesting 4D agency must ensure the limited grounds for UIFSA 319 are met and that a change of payment location is not only permissible, but the most appropriate option. If California determines that redirection is the most appropriate service for the family, given the facts presented here, it may send a request to Texas on the new form that we will discuss in a few minutes. The Texas 4D agency will facilitate the UIFSA Section 319 change of payment location from its SDU to California's SDU. The Texas 4D agency will also facilitate the issuance of a new income withholding order or an administrative notice of change of payee to the employer in Florida. As you can see, after redirection, the payments will go from the employer in Florida directly to California's SDU, bypassing the SDU in Texas altogether. If Texas needs information on those payments and requests such information from California, UIFSA Section 319 requires California to provide a certified statement of the amount and dates of all payments received. When revising the intergovernmental forms, the work group decided the most effective way to facilitate 319 requests was on a new standalone form which we will describe in just a moment. Before moving on to the form, however, we want to pause to recognize that UIFSA 319 is complicated and has been the cause of confusion among states. We don't have time to discuss this provision at great length today, since the purpose of the forms training is to introduce you to all 13 of the revised intergovernmental forms. However, OCSE is working on policy guidance to assist states in the complex area of interstate payment processing, including UIFSA Section 319. Now I'd like to turn it over to Jeanette to tell us about the form itself.
Thank you, Bill. So you should be looking at slide 1 for this 319. We're just going to call it the 319 form because the name is so long. And I just want to make a comment here that though it is complex, it doesn't have to be frightening. The process can work very effectively. So we're going to talk about how to make that happen using this form. So Bill and Debbie have covered the basics, but let's look at the form and see how you would use that. And both the requesting agency and the order issuing agency or tribunal use this form. And as I said, going forward, we're going to just call it the 319 form. So this is the last of the 4 new intergovernmental forms, and we've covered the other 3 in the previous trainings. This form may be used, as they talked about, by a 4D agency providing services to an obligee to make a Section 319 request to the state that issued the support order to change the payment location of the order. The form may also be used by a 4D agency responding to a 319 request. And it's important to note that only 4D agencies can request redirection. There is no provision for this in non-4D actions. When drafting the form, the work group identified the necessary data elements for states to make and respond to a UIFSA Section 319 change of payment location request. The form sets out the statutory requirements and identifies the issuing state's order, the parties, and the children for whom support is provided. A state only makes a Section 319 request when it does not have an intergovernmental 4D case open with the order issuing state. If the 2 states already have an open 4D case, payments would already be flowing between the states and redirection would not be necessary. Therefore, the header on the form uses requesting and order issuing to identify the agencies and states involved in this request, in lieu of using the terms initiating and responding like you would see on most of the transmittals. The heading informs the requesting agency that it must also attach a completed Child Support Agency confidential information form, which records the PII for the case. The UIFSA 319 form is a standalone request. No additional transmittal form is needed. Note that a transmittal one actually should not be submitted with this form, as this is not a request to open an intergovernmental case. And there are currently no SysNet transactions for this UIFSA 319 request or response. So you can see on the bottom of this slide that there's no checkbox in the notes section for SysNet. Moving on to the 319 form, slide 2 now. Just under the heading, the form lists the statutory requirements for requesting a change of payment location under UIFSA Section 319. A 4D agency cannot request redirection unless all of these requirements are met. These requirements are: the obligee must be receiving 4D services from the requesting agency. The tribunal in the requested state or the order issuing state obviously must have been the one that issued the support order. And neither the obligee, the child, or the obligor reside in the order issuing state. And as I just stated before, redirection can only be requested by a 4D agency. I also think one of the things that makes this a little confusing is we're using the term redirection a little differently than it was used previously on the transmittal number 1, but this is how the statute uses it. As noted under Section 1 action, the requesting agency sending this form is asking the order state to either the agency or the tribunal to do the following. Direct that support payments be made to the requesting agency's state disbursement unit. And I want to be really clear here that what this does is takes the order issuing SDU out of the middle of the payment flow. To issue and send to the obligor's employer a conforming income withholding order or an administrative notice of change of payee reflecting the redirected payments, and to forward to the requesting agency a copy of the tribunal order or administrative notice that redirects the support payments, and if they did an income withholding order, to forward a copy of that. When the order issuing state receives a request that meets the requirements, UIFSA Section 319 does impose a limited legal duty on the order issuing state to redesignate the payment location on the support order to the requesting state's SDU and to either issue an income withholding order or an administrative notice of change of payee. The form contains an option where the requesting agency also may request a certified arrears calculation or payment record as of the date the payment location was changed. The requesting agency then can use this information to accurately set up its SDU account in preparation for receiving payments from the obligor or the obligor's employer. Section 2 on the bottom of this slide is case information, and this provides space for details about the order. The requesting agency must provide the following information about the order, if it's known: the date of the support order, the state and county that issued the order, the tribunal number, which sometimes is called a cause number or a docket number, and the support amount and frequency of the ordered payments. And make a check in the box that you see right on the bottom of this slide if a copy of the existing support order is attached. And that might expedite the request, especially when the case is non-4D in the order issuing state. And the 4D agency then can use the copy to request a change of payment location from the appropriate agency or tribunal. Now on slide 3 of the 319 form, it begins with section 3, which is obligee information. This is very basic information about the obligee to whom the requesting agency is providing 4D services. As we've seen on the other forms, of course, most of the PII is provided on the Child Support Agency Confidential Information Form. Therefore, only the obligee's name and a little bit of caretaker information, if the caretaker is involved, is needed on the actual 319 form. This personal information is necessary to ensure that the order issuing state is identifying the correct order. Similarly, the Section 4 obligor information asks only for the obligor's name, and Section 5, the dependent children, lists only the names for the child or children covered under the support order. In Section 6, other pertinent information, the requesting state should provide any additional information that they feel might be helpful to the order issuing state's agency or tribunal. An example might be a federal employer identifier number, which is called the FEIN, of the obligor's employer, if they know that information. If the information that is entered into Section 6 is related to a previous section, please be sure to identify the section and the item number, and if you need additional space, check the box that says additional case information attached, and attach your additional documents. On slide 4 of the 319 form, Section 7 provides contact information, and that contains the date of the request. This is the contact information of the requesting 4D caseworker, so the state that is providing services to the obligee. And we are hoping that you will include email, direct phone number, and fax number if possible. We've talked about this on other forms, and we certainly believe that providing direct contact information, if it's permitted under your state's procedures, will expedite communication between the jurisdictions. The response section of the 319 form begins on slide 5, and this is used by the 4D agency in the order issuing state to respond to the request. The requesting state agency should always include the response pages with the 319 form, and it is the requesting state agency that completes the header information on this part of the response. The requesting state agency's information would be listed in the to section, and the order issuing state's information in the from section, since this information will be being returned to the requesting agency from the order issuing agency. The order issuing state then completes sections 1 through 3 of the response form and returns it to the requesting agency, and we're going to go on in the next slides to see those sections. So now we're looking at slide 6 of the form in section 1, response. The state forwarding agency in the order issuing state checks the appropriate response or responses, and again, there may be more than one. If you're responding to the 319 request, check item 1 if you're providing a copy of a tribunal order or an administrative notice to change the payment location of your state support order to the requesting agency's SDU. Check item 2 if you're providing a copy of a conforming income withholding order or administrative notice reflecting the redirected payments that was sent to the employer, and identify the employer. If the employer is not known, check the box, employer is unknown. Remember that the 319 request redirects all payments. So an obligor may be making payments directly and there's no employer known. But this still might be an appropriate action. Check item 3 if you're providing a certified arrears calculation or a payment record as of the date of the redirection order or notice. Check item 4 if the limited grounds for UIFSA Section 319 are not met. You want to be sure to provide the specific reason in Section 2, other pertinent information, so that the requesting agency will be able to take the appropriate action for their case, and so that they'll understand why you are not proceeding with the redirection. And you want to check item 5 to provide a different response than those listed above and explain in the response section. The response, which is section 2, other pertinent information, is for other attachments and information that weren't listed above. If the request can't be processed, as we've talked about, and you've checked section 1, item 4 or 5, then you want to provide an explanation. And again, if you need additional space, check the box that says additional case information attached and provide that information. There are a number of reasons why you might not be able to meet this request. The most common one would probably be that one of the parties still resides in the order issuing state. You might also be responding and saying, we need additional information before we can do this. For instance, you're not able to identify the support order. Looking now at section 3 near the bottom of the form, section 4, I'm sorry, near the bottom of the form is contact information, and this again contains the date, and this, however, is the contact information for the order state's 4D worker who is responding, again including email, direct phone number, and fax number. It's important to remember, it's extremely important for the two agencies to communicate with each other and work together on these requests, especially since they are new, and it's going to take everyone a little while to get used to how and when to use this process. And now I'm going to continue with the scenario. Thank you. I was thinking I was going to turn it back over. We're going to look again at that scenario that Bill described to us earlier, now that we've seen the form, and we're going to talk a little bit about how you would use the form in this scenario. So as Bill talked about, in the upper part of the scenario, the obligor in Florida is making payments to the Texas SDU as Texas issued the order. Texas is sending those payments directly to the obligee in California, as no other agency is involved in the case. It's also important to realize we're looking at one scenario here. This is not necessarily the only scenario where this might be applicable. In the lower part of the scenario, the obligee is now receiving services in California, and the order, of course, was issued by Texas. None of the parties live in Texas, and Texas and Florida do not have an open case. California looks at all the facts and determines that the best course of action is to request a 319 redirect of the order. The California 4D agency would then send a request to the Texas 4D agency to change the payment location to the California SCU using this form. On the form, California first completes the heading information. It's particularly important to include the payment locator code and remittance identifier, what you call your case identifier or your account number, so that the order state will be able to properly direct the payments in any new income withholding order or administrative notice. California then completes the order information under case summary, the obligee information in Section 3, the obligor information in 5, and the information about the child or children in Section 6. If California has a copy of the support order, it's helpful to attach it to the form. Finally, if California would like Texas to send payment or balance information, it should check that box in Section 1 and request that information. The agency or a tribunal in Texas then, depending on Texas law and how Texas determines to handle these actions, will direct all payments to the California State Disbursement Unit, either by judicial or administrative order. Texas would check number 1 on the response action of the form and provide a copy of the tribunal order or the administrative notice to change the payment location. They would send that back to California. Texas also might issue either the income withholding order or the administrative change of payee, again, depending on Texas law and procedures, and send a copy to the employer if the employer is known, and also sending a copy to the 4D agency in California and the obligor. If they're sending this, they would mark number 2 on the response section of the form, since the order or notice has been sent to the employer. Texas checks number 3 on the response form if it's providing a certified arrears calculation or information on payments received through its SDU. Again, this is worth repeating. UIFSA is state law. States must follow state law and procedures in meeting the requirements under UIFSA Section 319. Federal law requires the State Disbursement Unit to be the designated payment location, and requesting states will be required to provide their SCU address as the new payment location. Also, a state providing services to the obligee is never obligated to send a 319 request. In many cases, especially where the order issuing state has an open 4D case and is currently enforcing its order, initiating a 2-state case or requesting payment forwarding may be the more appropriate option. Finally, OCSE strongly recommends that the requesting agency contact the order issuing state and check federal resources, as Bill talked about, QUIC, or the Federal Case Registry, before sending this form to ensure that the limited grounds of UIFSA 319 are met and that a change of payment location is not only permissible, but the most appropriate action. I'm going to turn it back over to Bill at this point.
Thank you very much, Jeanette. That concludes our review of the UIFSA 319 form. We wanted to touch again on the effective date for the revised forms. I know we've talked about this in the previous sessions, but we wanted to provide this so for folks that are just joining us this time around. You may be wondering when you must use these revised forms and when you might start receiving them. We know that some states have begun programming for the revised forms, so you might receive revised forms at any point if you haven't already. They are valid now. The deadline for all states to begin using the revised forms is January 15, 2018. The delayed date is to give states time to program these changes. Until then, the old forms are still valid and should be honored. We'd like to open up the lines again for any questions that you might have regarding today's session. We have a few minutes left.
As a reminder, to ask a question, please press star 1 to record your name. Again, to ask a question, please press star 1 to record your first and last name. One moment to see if we gather questions.
Do we have any telephone questions? If not, I do have a few on the Q&A.
There is a question from Young Kim. Your line is open.
Okay.
Hey, this is Joan Kuhn. I have a question about at the beginning of the 319 discussion, you indicated that if you receive a 319 redirect request, that it must be honored by the requested state. What happens if you get the 319 request in and it's not appropriate? Let's say our state still has a case open for assigned arrears, that it wouldn't be appropriate to redirect payment. At that point, is it acceptable to then pick up the phone, contact the other state, and to inform them of the problems and try to basically negate the 319 request?
Well, I think as we've emphasized today, certainly communicating is a good idea. But of course, if the requirements are met and the form is sent, then yeah, you have that obligation to comply. But certainly talking to the other state and working out something is what would be expected. Jeanette, any comments on that one?
Yeah, this is not an uncommon scenario. Colorado, I worked for Colorado for a number of years, has been doing these requests for quite a while, and this happens pretty often, and so that's exactly what we did. Pick up the phone, talk to the other state, and say, we still have state debt due. Will you send us a case? Or sometimes an option is for both states to send a case to the state where the obligor is residing. So it's not if the requirements are met, you have to comply. But part of that can certainly be working with the other state to find what you think might be a better option.
I have one other question as well, if you don't mind. You had mentioned that OCSE was going to have policy coming out regarding payment processing. When can we expect that?
Hi,
Go
Bill.
ahead, Liza. Sure,
Hi.
Liza.
This is Liza Lowe from the federal office. We are working on this policy, and it's a pretty extensive one, and it's much broader than just 319. It's on interstate payment processing across the board, and it's been in long development. We expect it out in the next month or so. So please look out for it. And I would say that this policy should be very helpful in creating some shared ground for all of us who are working interstate cases. And from then, we can get into more complicated scenarios. I do think that the policy will help us understand what 319 requirements are. Of course, it's state law and not federal law. So the federal office doesn't generally comment on UIFSA. So again, I just want to reinforce what Bill was saying and Jeanette about communication among states as we implement these complex laws. And certainly interstate has a very complex past history, and we're hoping this policy will help. Thank you.
Thank you.
Do we have any other questions on the telephone?
The next question comes from Eleanor Tate. Your line is open.
Hello again. I have two questions. Explain to me again what the remittance identifier is.
That's your case ID or account number, however your SDU would identify the payment when it was received.
Okay.
And Bill, this is Liza again. I would just add that we tried to match up the form with what's on the income withholding order. So there is a space for remittance identifier on that form. So we want to provide, this form is providing as much information to enable the order issuing state to complete that IWO form if that's part of this process.
Thank you. Second question is, what is the site to go to after the call is over, or when you guys get the information online, that we can go back and review the information that you've given today?
The presentations and the notes will be available on the OCSE website. I believe that the information or the presentations and notes from Session 1 and Session 2 are already available. Is that correct, Liza?
I think we're close to getting Session 2 up, but Session 1 is up.
Okay, and then all of these will eventually be available on the OCSE website.
And we're also working on getting a recording completed as well.
Okay. Thank you guys so much.
Welcome. I do have a few questions on the Q&A, but some of those are sort of policy related, and I believe the AT, when it comes out, will probably be able to handle and address some of those scenarios. But I do have one generally. It says which agency would need to send the termination of the income withholding after redirection completed, and without getting into a lot of details or different scenarios. Generally, the agency that issued the income withholding or an agency or tribunal that has authority to terminate the existing income withholding would be the one that would have to do so.
So, Bill, this is Diane Putz. If I could just follow up a little bit on that. I think the question contemplates really two possible scenarios. You know, one is what happens at the time of the redirection request, and then what happens subsequent after redirection is accomplished. So the order issuing state, when it receives a redirection request, if it meets all the criteria, needs to take the steps to facilitate redirection. And that could include, depending on state law, a new income withholding order. If it does issue a new income withholding order and there's an outstanding income withholding order with the issuing state's SDU as the payment location, it's going to need to terminate that as part of that whole facilitating redirection process. The question could also be talking about if down the line that income withholding order that was entered that has the new state's SDU as the payment location, what happens then? And so it's going to be the 4D agency that's providing services to the obligee that's going to be responsible for if a new WIW needs to go out or it needs to be terminated. It's going to be up to that enforcing 4D agency to accomplish that after redirection occurs. Thanks.
Thank you, Diane. Any other questions on the telephone?
At this time, I show no questions.
Okay. I'll read one of these Q&As that we received. So in this example, Texas is no longer getting payments. Does it keep its case open even though not getting payments? Is this an intergovernmental case? Would only California have the open case? What if enforcement became a problem or someone wanted a modification? Well, there's quite a number of questions within that, and I do think that some policy coming out will be helpful there, and a number of scenarios involved. But primarily, the communication is key there, and maybe the 319 request is not appropriate given the various scenarios presented. So.
And Bill, this is Diane again. If I could just follow up with that. I think it's important, and there was another question on this as well, that a request to redirect payments under Section 319 is not a request for the order state to open a 4D case, and in our scenario, it was a closed 4D case. So if Texas receives that request from California, it doesn't have an open 4D case. It shouldn't open one. It should do what it needs to do to facilitate the request and get those payments directed to California's SDU, but it's not going to turn it into an intergovernmental case. And, once redirection occurs, then Texas's SDU is going to be out of the payment loop altogether, and payments will flow directly from the employer in Florida over to the California SDU.
And I would just add, if enforcement becomes a problem or someone wanted a modification, California is going to handle it just like they do on any case. So if someone wants a modification, they're going to look, in this case, to the non-requesting party state, which might be either California or Florida. They might be sending a case to Florida to register and enforce the Texas order if enforcement becomes a problem. So at that point, you're handling it. All this process does is get the Texas SDU out of the middle so that California can get payments directly.
Thank you, Jeanette. And I do think that your responses there have addressed a couple of the questions that we've received. Are there any other questions on the telephone?
So no questions at this time.
I think I might have one or two questions from the previous discussion of the general testimony. If the initiating caseworker did not complete the healthcare section and did not complete the continuing section 4.5 and 6, would this section be considered complete or incomplete? And as a responding state, should we continue? There's another question I think that's similar. If the petitioner doesn't fill out or return the general testimony, do we proceed without it, or do we fill out what we know and send it? Both of those questions are not new to the general testimony and intergovernmental sort of case processing. I think you pretty much have to complete the forms as best you can. I think for the most part, the general testimony is required if you're asking another state to take certain actions. And so it does have to be complete as best you can or as best the petitioner can. And certainly, as we've discussed, sometimes the 4D worker has to complete the form and sign it and send it as well. And like I said, we've gotten a couple of questions about the 319. A lot of scenarios involved there, and we're looking forward to additional guidance from OCSE's Division of Policy and Training. And I think we're running a little short on time. If there are no more questions on the telephone.
At this time, I show no questions.
We want to offer the email address on this slide to submit any additional questions. And remember that these slides and notes will be available soon on the OCSE website. So we want to thank you once again for participating in today's training and for all of the great work that you do. Thank you.
This concludes today's conference. Thank you for your participation. You may disconnect at this time.
Are we in post-conference?
I think so. Didn't hear all the beeps.